All right, welcome everyone to today's webinar, Preparing for Dementia, a Legal Perspective with Leanne Kuczynski. So welcome, Leanne. A couple of housekeeping notes before we get started. You guys will notice that your video and your sound have been shut off, and we ask that everyone keep them off for the duration of the presentation. There will be an opportunity to ask questions at the end of Leanne's presentation. So we ask that you enter any questions in the Q&A. So if you move your mouse or touch your screen, somewhere on there will be a little couple boxes and it says Q&A, and you can just click on that and type any questions that you have in there. All right, so it's my pleasure to introduce Leanne. I'll give you a bit of information about Leanne. So Leanne is an associate in Siskin's General Litigation Group. She primarily practices in the areas of estate and capacity litigation. Leanne has significant experience in estate and capacity matters and routinely advises and represents clients in disputes concerning the validity and interpretation of wills, disputes regarding the validity of power of attorney documents, claims seeking assistance from the court regarding the proper administration of an estate, claims against trustees and attorneys for actions taken in the course of carrying out their duties, as well as passing of accounts and applications. Leanne has further acted as an agent for the Office of the Public Guardian and Trustee. So I think she's got lots of information that she's going to be able to share with us today. I think we're really interested in hearing about power of attorneys and all the different issues that come up with that, and capacity issues and that type of thing. So I'm going to turn it over to Leanne.
Great. Thank you so much, Tara, for the introduction. Also, on a personal note, I am a lifelong Londoner and I have ties to McCormick Home. My grandmother was a resident at the previous building and then also at the current building as well. So I have personal experience as well as professional experience in the considerations that should be made when a loved one has dementia and preparing for that. So thanks again, Tara. And I'd like to say also thank you to the McCormick Home team for having me to present on these very important issues. And yeah, so thank you. I'm very happy to be here. All right, so today I am presenting on the legal considerations when preparing for dementia, but then also the considerations that need to be made once the dementia has developed. Specifically, I will be presenting on the following topics. Next slide, please. Sorry, we had some technical difficulties earlier. All right, so first I'm going to discuss what is capacity. How do we define what capacity is? What are the different types of capacity? How do I know if my loved one has capacity? And then I'll also discuss dementia diagnosis and what that means with respect to whether someone has capacity or not. Then I'm going to discuss powers of attorneys. What are they? How do I make one? When is it in effect? When is it no longer in effect? And then I will discuss guardianship applications. So these are tools used when a person does not execute a power of attorney. So I'll discuss what that means and what the process is for that. And then I will go over the duties and responsibilities of powers of attorneys and guardians. We'll discuss what should you do, what should you not do, and I'll provide some guidance on some of kind of the best practices for powers of attorneys and guardians. And then I'll go into some common issues that as a litigator we see in power of attorney matters, and I'll discuss kind of how we deal with it or how you can deal with it. And then also discuss some of the red flags that we've developed throughout our time and kind of the indicators that there may be some financial elder abuse and what you can do to address the concerns in the event that you do see this occurring. And then lastly, we'll go over question and answers. And again, please feel free to put your questions in the question and answer portion of the Zoom meeting, and we can go from there. I've also developed some commonly asked questions that I get as well, so we can go over those too. All right, next slide. What is capacity? So capacity, I find the term very general and vague. what is capacity. And so just for preparation for today, I went on, just Googled capacity. And so I came across this Cambridge dictionary definition. And capacity is defined as someone's ability to do a particular thing. Again, I find this a very vague concept again. Looking towards our kind of general legal definition, capacity is defined as whether the person is able to understand the information that is relevant to a particular decision, and whether the person is also able to appreciate the reasonably foreseeable consequences of making or not making that decision. So when we look at the concept of capacity from a legal perspective, we're looking at kind of a two-pronged test. So again, first, whether the person understands the information that is relevant to that particular decision that's needing to be made, but then also whether the person can appreciate the consequences of if they make that decision or if they don't make that decision. And so in the next slide, I'll go over kind of the different capacity decisions that are need to be made in relation to our fields. And then lastly, capacity is decision specific. And again, I'll go over the different decisions that are needing to be made when someone's preparing for dementia or has dementia. And then also capacity is fluid. So capacity, so a person may have capacity one day for a particular task, and then the next day, they may no longer have capacity for that task. And we do see this often with patients with dementia, that capacity can change, particularly it can even change during the day. Like from my understanding, capacity in individuals that have this may be more, maybe higher earlier on in the day versus later on in the day. So those are considerations that as lawyers we consider as well. And then also it's important to keep in mind that capacity does not mean that the person needs to make the right or the best decisions for themselves. Capable persons make terrible decisions every day, and they have the right to make terrible decisions every day. Using nutrition for an example, like I know that if I don't have breakfast in the morning, that it's not the best decision for me health-wise. But I understand the information relevant to make that decision. And then also I can foresee the consequences of not eating breakfast and that I'll be hungry later on and my blood sugar level will spike once I eat. So again, capacity, it does not mean that you need to make the right or best decisions. Next slide, please. All right, so as stated, capacity is decision specific. So again, we're looking at that two-pronged test. One, whether the person understands the information that's relevant to that particular decision that needs to be made. And then two, whether they can foreseeably see the consequences of making that decision or not making that decision. So in my fields, we generally see assessments, or we have to determine these different decisions that need to be made. So I'll just briefly go over them. So first, to grant a power of attorney for property. So this is looking to whether the person has the capacity to appoint a person to manage their property in the event that they become incapable. So this would be whether the person can appoint someone else to be their power of attorney in the event of incapacity. Next, to grant a power of attorney for personal care. So this is looking to appoint a person to manage the personal care decisions in the event of the person's incapacity. Then there's management, whether the person can manage their property, and capacity to manage their property is looking at whether the individual can make decisions regarding their property, and in particular, whether they can pay their expenses, whether they can manage their real property, so their house, whether they can make investment decisions or oversee investment decisions, file taxes, that kind of thing. And then manage personal care, so capacity to make decisions concerning their shelter, so where they're going to live, safety, whether they can make decisions as to whether the place they're living is safe for them, whether physical limitations. And then also there's nutrition that's considered, clothing, healthcare, as well as hygiene. So we're looking at whether the person can make decisions with respect to those 6 areas. And then lastly, we also assess whether someone can make testamentary decisions. So whether they can execute or give instructions and execute a will. So again, the capacity to make these various things require different levels. Sorry, can you go back to the previous slide? Sorry, thank you. So there's different levels of capacity for these various decisions. And just for an example, so the capacity to grant a power of attorney for personal care, it is a lower threshold, and I would argue probably the lowest threshold required regarding capacity. It does require less complex decision making. So just for the test, the legal test. So to grant a power of attorney for personal care, you must be 16 years of age. And again, the person needs to understand the information relevant to make decisions regarding, let's say, their shelter, and then also whether they can reasonably, that was the capacity to manage personal care. The capacity to grant a power of attorney for personal care is just whether the person understands that the proposed person that they are thinking to appoint as their attorney has a genuine concern for their welfare, and then also appreciates that they may need to have that person there to manage their personal care in the event that they become incapable. So it's a lower threshold because basically they just need to know that the person has a genuine concern for their welfare, and that they appreciate they may need someone there to manage certain personal care decisions in the event that they're no longer able to do so. So it's a lower test. Whereas to grant a power of attorney for property, there is more considerations that need to be made. So it is a higher threshold. So for the test for whether someone can grant a power of attorney for property, they have to be 18 years old instead of 16. And then also they need to understand the property that they have, and then also understand the approximate value of the property that they hold. They need to understand the obligations that they owe to their dependents. And then they need to understand that the attorney, whoever they may appoint, will have the authority to manage their property and do everything that they could do while capable, except make a will. They need to understand that the person will need to account for their actions with respect to the management of their property. They also need to appreciate that the person may misuse their authority while managing their property. So there's a bit more considerations that need to be made, and more questions to be asked to assess capacity. And then to make things a little bit more complicated, there's also different tests for management of personal care and then management of property, which considers those two-pronged tests. So whether they understand the particular, the information relevant to making that decision, but then also the consequences of not doing something as well. So a bit more of a threshold for capacity for management. With respect to capacity to execute a will, similar considerations are made when considering whether someone has the capacity to grant a power of attorney for property. For example, they need to understand the nature and value of their assets, where those assets are held. Again, understand those who may stand to inherit, so dependents. Then also they need to understand the nature and effect of a will. So what is a will? What does it do? So there's different legal tests that we have in order to assess these things. And also it's important to note that a person, particularly a person that may have dementia, they may have the capacity to grant, let's say, a power of attorney for personal care, but they don't necessarily have the capacity to manage their personal care. So, because again, there's different thresholds for each of these decisions that need to be considered. So that's why we've developed these legal tests when someone comes in and they want to, or they're looking to update, let's say, their powers of attorney or update their will. So next slide, please. So we get this question often. So does a dementia diagnosis indicate that the person is incapable? The answer is no. So a dementia diagnosis, it doesn't impact the assessment of whether the person is capable of making certain decisions. Of course, it's a consideration that needs to be made. And if the person does have a dementia diagnosis, it's probably if you're going to see a lawyer, let's say, to execute or update new powers of attorney or a will, it would be important to just advise the lawyer that this diagnosis has been made, but it doesn't mean that that they're incapable of all decisions. As we know, like dementia has varying levels, and from mild to very severe, and it can take and it changes from person to person, but it may be a short period of time that it gets to severe, or it could be over many years. So it is important to have a lawyer there to assess capacity and whether they can make, let's say, granting a power of attorney for personal care and property, but they may not have the capacity to, let's say, manage property, or they could have capacity to do all decisions. So, you know, but again, varying levels of dementia. The person is the same day after diagnosis as the day before. So it's important to keep that in mind. Next slide. So how do I know if a person lacks capacity? And this, as a lawyer, can be very, very difficult to determine. And it's something that I come across a lot, trying to ascertain if someone's incapable and when was that date that they became incapable. And it's almost impossible to determine that. And, you know, you can't say this is the time and date that this person lacks capacity to make this particular decision. Like, it's very, very difficult. So I look to like family doctor notes, their assessments, social worker assessments. Family members can look to that as well to get an idea of the extent of the level of cognitive impairment if there are concerns. So that's a method that the individual can go to. MOCA assessments, I'm sure some of you may have come across this. These are assessments that are used through like social workers, hospitals, nursing homes, and they do ascertain the level of cognitive impairment. The problem with these assessments, though, in the legal context, it's not the legal test being used to determine what the person's capacity is to make certain decisions. But, you know, it is a good indicator to understand the level of cognitive impairment and whether more assistance is needed by the power of attorney if one has been appointed, and also the extent of the assistance. And then lastly, designated capacity assessors could also be retained to do capacity assessments. What I love about capacity assessments by designated assessors is that they use the legal tests that we look to determine whether someone is able to make a specific decision or not. These assessments, however, are quite expensive, particularly if it depends on like what you're looking for the assessor to assess. So sometimes it can range from 500 to about 2,000 if you're asking for all assessments to be made. We only really resort to those assessments if we are concerned when someone comes in to do a power of attorney or a will, or if there hasn't been a power of attorney in place when we're doing guardianship applications, which I will discuss later on in my presentation. And then if there is a capacity assessment that needs to be completed, it must be kept in mind that the person needs to consent to the assessment. And if consent cannot be obtained by the person, then there are opportunities, particularly if there is a safety concern, to bring a court application and getting a court order for a capacity assessment to be completed. But yeah, consent is very important for getting these assessments, because it can be an intrusive process, and you're asking personal questions, and you're telling someone that you have concerns about their capacity, which it's a big deal. So that's why there needs to be consent for these assessments. Next slide, please. Okay, so if a person is found to be incapable, or you believe that they are incapable, then a power of attorney document needs to be utilized. So what is a power of attorney? So a power of attorney, it's a legal document that gives another person the right to make decisions for you during a time that you are incapable of managing your affairs. There are two types of power of attorney documents, and they are separate documents. One is a power of attorney for your property. So that includes real property, so land, house, and also personal property. So going from bank accounts, investments, also the contents of your house, any valuables you may have. That person that you appoint will have the authority to manage those items when you're unable to do so. So you're not required to have a power of attorney in place. It's not a requirement by law, but it is a very important document to have in place. And I will go into what happens if you don't have one in place in a bit. And then I get this question often. A power of attorney is very different from a last will and testament. Powers of attorneys are used when the individual is living, and it's only for the management of your property and personal care when you are still living. So when you appoint someone as your power of attorney for property, again, they're managing your finances, again, real property, filing taxes if need be. So they're stepping into your shoes for financial management decisions. Personal care, I find that this is also another question. So personal care, managing someone's personal care is not the same as providing care. Of course, that may happen in certain situations where appropriate, but really, if you're just making sure that person is getting the care that they need in those 6 domains that we were originally talking about. So shelter, safety, nutrition, clothing, and healthcare. Again, depending on if the person's incapable of all those decisions, I often find that someone may be incapable of maybe determining shelter or safety, but then capable of making nutrition decisions and clothing. But it's important to keep in mind that doesn't mean that you have to provide the care, but of course there are circumstances where that happens. Next slide, please. Okay, so how do you make a power of attorney document? So lawyers can assist with the preparation of these documents for you. You could also find these documents online. However, we recommend that you don't do this because we see litigation often arising when powers of attorneys or wills are done via kits online. And this is because, let's say, the formalities of the power of attorney document are not followed. So let's say I've seen documents not signed by the grantor and then also not being witnessed. So that is not complying with the formalities of the document. So they are invalid. So again, formalities of the power of attorney document, they need to be signed by the grantor, witnessed by 2 people in the presence of the grantor. And then also the power of attorney document cannot be witnessed by the spouse or children. Also, when a lawyer is not involved in this process, the lawyer is not there to assess capacity, whether the individual had capacity to execute that document. And then also the lawyer cannot assess undue influence. And undue influence is it's a legal term that we use when others surrounding the grantor, let's say, coerce that individual into signing something. And that's usually, we see them signing authority to that individual that's coerced them because the person feels that this would benefit and like them personally, and then also gives them control over the other person's finances. So it's nice to have a lawyer there to assess for these flags and also to ensure that capacity is there and that the person wants to execute these documents. When you are executing a power of attorney document, probably the most important decision is who you are going to appoint. So you have to consider whether the person that you're going to appoint is going to act in your best interests, is not going to use your funds for their personal benefit. Their geographical location is very important. Like if there's an emergency, having someone close by, that is an asset that we found. Like, so if there's an urgent need for a nursing home placement, like, it is good to have someone around that can assist you in doing that. For appointing, you can appoint 2 or more people, or you can appoint just 1 person. If you do appoint 2 or more people, you have the option of considering whether you would like them to be appointed jointly or jointly and severally. A joint appointment would mean that the 2 individuals or 3, whatever, have to act together in making those decisions. All would have to, let's say a bank account was going to be opened for the management of your funds. All 2 or 3 attorneys would need to sign the documents. So there is some difficulties that can arise when there's a joint appointment. So like if there's disagreement between the attorneys, so you want to make sure that everyone gets along, can act reasonably together, will not go off and do something without the other 2 or other person's consent. It also, when you do a joint appointment as well, it does not make things as efficient. So again, you need everyone to sign all documents, agree with all decision making. So those are considerations that need to be made. The other option is that jointly and severally appointment. So what that means is not all attorneys that are appointed would need to agree on every decision. It gives the appointment, allows one attorney, for example, to deal with the opening of the bank account or dealing with the placement into the nursing home. So we see that as well. And again, if it works for your particular situation, then that's great. a potential problem, if you do jointly and severally, you need to make sure that the attorneys that are appointed, again, work well together, and one's just not going to unilaterally make decisions without like unilaterally making material decisions that the other person doesn't know about. For example, like selling a property or changing kind of the designation of the property, how the real property is held, that kind of stuff. So these are important considerations to be made, but sometimes they do work great. Also, for the appointment of attorneys for property and personal care, you don't have to appoint the same person or persons for both appointments. You can do different individuals for different roles. So we often see potentially like one child being appointed as attorney for property and then another as attorney for personal care. And but you need to, again, make sure that whoever you're appointing in, like, let's say those two categories, that they are aware of what's going on, because situations can arise where there isn't communication and there's disagreement, which can result in concerns and then sometimes litigation. So again, you need to make sure that the individuals can work together and all of them will act in your best interests. All right, next slide, please. Okay, so when and how is a POA enacted? And this also can be difficult to pinpoint the correct time of when to get the POA, to use the POA. So first, it really depends on the wording of the power of attorney document. So if you have concerns about someone not having capacity for whatever decision that needs to be made, look to the power of attorney document that appoints you and see if there's any restrictions on when you can use it. So first, generally for powers of attorney for property, the ones that are executed are continuing powers of attorney for property. So these documents are prepared and they take effect immediately. And the reason why the continuing power of attorney for property may be of assistance in a lot of cases is they take effect when someone's incapable and the person can take the POA document to an institution such as a bank or a nursing home when there are concerns of capacity. So the other side, like if you don't have a continuing power of attorney for property, or the power of attorney for property document specifies when the POA can be used, such as in the event of incapacity and that there's evidence that's needed of that incapacity, that can cause problems such as if urgent decisions need to be made, such as selling a property, placement into a nursing home. So, it's a consideration that needs to be made, although some people like having that clause in their power of attorney document saying that a doctor's letter or capacity assessments needed to evidence that they actually are incapable, and then the power of attorney document can be used. But again, the wording in the POA document will specify whether a doctor's note or capacity assessment is required. I will say that these are rare. We don't see them very often. Usually it's a continuing power of attorney for property that we see. So again, look at the document, see if there's any restrictions, and then you'll know if you can use it, if you have belief that the person is incapable, and then you can use the document at institutions such as the bank or the nursing home. So yeah, next slide, please. Okay, so a POA is no longer in effect when two situations happen. So first, the POA is executed, a new POA is executed by the grantor, which then revokes the previous power of attorney documents that were executed. And then 2, after the passing of the grantor. So powers of attorney documents are only valid during the lifetime of the grantor. And then after the grantor's passing, the last will and testament comes into effect. And then whoever's named as executor in the last will and testament then handles the administration of the estate. Next slide, please. Okay, so if you do not grant a power of attorney document, whether for property or for personal care, this obviously leaves uncertainty regarding who will be able to manage your property and personal care during a time that you are unable to do so. So if no POA has been executed and the person is believed to be incapable of managing either their financial or personal affairs, then someone's going to need to apply to the court to be appointed as, we call it, guardians of property and of the person. So a guardian of property is akin to an attorney for property, and then guardian of the person, again, akin to attorney for personal care. And the appointment is done via a guardianship application. Next slide. So guardianship applications, they're commenced with the court. And once appointed, the guardian will have the same authority as an attorney for property and an attorney for personal care. And then again, they'll have the same restriction of not being able to make a will. That's one thing that, again, an attorney or guardian cannot do. So you can complete the application materials through forms online. However, I do wish to stress the importance of consulting with a lawyer because the application materials that are needed for these appointments can be onerous. And also the appointment is, you should be advised of the importance of your appointment and also your duties and responsibilities and what you can and cannot do, which I'll discuss in a bit. Regarding the evidence that's needed for the application, the proposed guardian needs to do an affidavit. And in that affidavit, they need to provide evidence that the incapable person is actually incapable of managing their property and personal care. And this is, again, the importance of capacity assessments that I talked about earlier, because the capacity assessment that's done, it actually uses that legal test that we were talking about earlier. And the court will heavily rely on that, and they need to make a determination that, yes, this person is incapable based on the assessment. Sometimes medical records can be used, but I often find that it's important and that the court fully is aware of the evidence that the person can't make certain decisions for certain things, and medical notes sometimes are not that illustrative of whether someone can, let's say, manage their property or their personal care. And then again, with the dementia diagnosis that are in medical records, it doesn't really shed light on whether that person can still manage their property or personal care or the extent of that cognitive impairment. So that's why we use capacity assessments for these applications. Also, the proposed guardian needs to present evidence to show that they are the most appropriate person to become appointed. And they need to submit a management plan in the event that they're being or they're applying to be appointed as guardian of property. And this plan sets out the plans with respect to what type of income this person receives, what type of expenses they have, or what savings accounts or checking accounts, what investments, whether they have any liabilities. That all needs to be set out, and you have to explain your plans with the property. For example, if there is a house and the individual is no longer able to live in the house and enjoy the benefits of the house, then it would make sense for the guardian to sell that house, so it's not incurring unnecessary expenses. And then the guardian would have to outline what would happen with those funds. So likely an investment in a GIC, TFSA, more conservative investments. And then for guardianship plans, that would be needed in the event that you're applying to be guardian of a person. And these plans just talk about what personal care decisions will need to be made, where the person will be living, if it's an appropriate placement, how are you going to foster personal contact with supportive family members, how are you going to consult with that person. So that's all included in the guardianship plan. So there's a lot of materials needed for these guardianship applications. And as you can appreciate, they can get quite expensive. So if the person's capable of executing a power of attorney for property and personal care, like it's very important those documents get executed, because if you don't, and property or personal care decisions need to be made, a guardianship application will need to be commenced, and it's expensive, and then also it takes time, which is not great if urgent decisions need to be made. And then for the appointment, again, it's similar to an attorney for property and personal care. 2 or more people can be appointed as guardians. An important distinction, though, is that only guardians can be appointed jointly. They can't be jointly and severally. So if you're going to have more than one person apply as guardian, they'll need to act jointly and make all decisions together. As part of this application process, we do have to serve these materials on the public guardian and trustee, and they are a government body in Ontario that oversees the management of the property and personal care for incapable adults. They will review the materials, they'll provide comments to the court, and then they'll file those comments with the court. And then the court will review those comments as well as the evidence that we've put forward, and then make a determination whether the person that's applied is the most appropriate person to be guardian. So there's also a concern if guardianship is necessary regarding competing guardianship. So if you don't have powers of attorney in place and you have, let's say, children that both want to be involved in managing property and personal care, they could both commence competing guardianship applications, saying that they should be appointed and the other person shouldn't be appointed. And again, that can be a costly process as well, and timing too. It would take quite some time with these matters. So again, important to have your wishes included in the power of attorney document. And then to give some context for guardianships or guardianship applications. So in the US, they call guardianships conservatorships. And you may have heard conservatorships being in the news recently with respect to Britney Spears' conservatorship. And so just briefly, her case really brings to light the need to ensure that the person that you are seeking to be declared incapable is in fact incapable. So that's why we have medical records, capacity assessments to show the court that, yes, this person needs assistance. And then also it shows the importance of ensuring that the alleged incapable person has agency throughout the process, and ensuring that they're aware of what's happening. And in Ontario, we do have some safeguards to ensure that the person has agency, and that includes these materials need to be served on the incapable person. And if they disagree with what's happening, they can attend court and oppose it. Also, if you're applying to be guardian, you also need to advise the person. We call it rights advice, and advise the person that this application is happening, and they have the right to oppose the appointment as well. So, yeah, it's an interesting case, and I thought that I would just raise it just to provide some context with what I'm talking about guardianship applications, because her conservatorship was throughout the news. And then, so lastly, to make things a little bit more complicated, guardianship applications can be used even if there's a power of attorney document in place. And we've seen guardianship applications being used as a tool when the appointed attorney for property has mismanaged finances, so misappropriated funds, or the attorney for personal care is not providing the appropriate care and has actually abandoned that person. So guardianship applications can be used when there's a removal of the attorney, and then seeking their appointment in that attorney's place. Next slide, please. Okay, so what are the duties and responsibilities of a POA and guardian? So again, attorneys for property, personal care, and guardians of property and personal of the person are for adults. Same thing, and they're both governed by the Substitute Decisions Act, which is legislation that's been put in place to provide guidance. And also the Substitute Decisions Act can also be found online if you just Google it. A lot of the information that we've talked about today is included in the statute. Okay, so first, attorneys and guardians are required to consult the incapable person regarding material decisions that are being made regarding their property and personal care, again, to ensure that they have agency and are involved in the process. To the extent that they are able to do so. Also, attorneys and guardians are required to consult supporting family members. So this, I've seen some issues can arise when supporting family members feel that they're not being advised of what's happening with respect to their, usually it's with siblings and parents. So what we see is one sibling having the role of attorney for property and personal care, and then not involving the other sibling or siblings with management decisions or information as to what's happening, and that can cause some issues and sometimes litigation. Also, this is a really important point, and I've touched on this previously in my presentation, but attorneys and guardians, so they can do anything with respect to the incapable person's property, except they cannot make a will. And this includes beneficiary designations, so life insurance policies, pension plans, some TFSAs, RIFs that have beneficiary designations. Those cannot be changed, and we do get a lot of questions about that, but making a will and also making a beneficiary designation, like that's a testament. Those are both testamentary decisions. And the court has ruled that attorneys and guardians cannot do that. And it makes sense because when the person is capable, they've made the decision to make their will a particular way. And they've also made these beneficiary designations. And these were choices made when they were capable. So the court will honor those. And this also prevents situations where an attorney and guardian are not fulfilling their fiduciary duty to the person, and they want to benefit themselves, and they'll make changes. So obviously this stops it and stops those concerns from happening, ensuring that the incapable person's wishes at the time that they were capable are followed through. And then also, just again for duties that the attorney for property has, they need to uh, file taxes, apply for benefits, manage investments, uh, collect debts, pay bills, maintain the house if the person is still living in the house, or that maintaining the house is still a benefit for that person, and then managing care as needed at nursing home. All right, next slide, please. And then, so attorneys and guardians have a duty to keep proper accounts of all transactions that are coming into and out of the incapable person's accounts. And this is probably where we see the most issues. And that's when someone's been put into this role and they haven't been keeping proper accounts of the transactions that have been made. And it doesn't mean that anything was ill-intentioned. It's just it's difficult to present an accounting of what's happened when proper accounts haven't been kept at the time that you were appointed as attorney and or guardian, and you were acting as attorney for guard and you were acting as attorney or a guardian. So just some kind of best practices for keeping proper accounts. For the development of bank accounts, it's important to limit the amount of accounts for that person. So if possible, having one account where direct deposits are being made and direct withdrawals for expenses are also being made from that account. It makes things clean and neat. Also, keeping like a file folder for bank statements per month, the receipts for any transactions that were made in that file folder, checks, and have it maybe organized by month or year, depending on the amount of transactions that are made. We also suggest avoiding the use of joint bank accounts and commingling funds. We see this often, commingling of funds between the attorney and the incapable person's funds, and it's very difficult to ascertain what part is the guardian's funds, and also it kind of sometimes leads to misappropriation of funds because funds have been encroached upon by the attorney for personal expenses. So avoid the use of joint bank accounts and commingling of funds. You must never use the incapable person's funds for your own personal use. You are in a fiduciary role and you are to act in complete transactions that are only in the best interest of the incapable person. If there is a guardian appointed, they must follow the terms of the management plan that's been approved by the public guardian trustee and the court. If there's investment accounts, seek the advice of investment advisors, and for filing taxes, also seek the advice of accountants, very important. And then if there are any concerns with the accounting or the accounts that have been developed by the attorney or the guardian, there is a court process called a passing of accounts, which formally requires an attorney or a guardian of property to present their accounts to the court to be approved. And then if there has been any misappropriation of funds or inappropriate management, then that gets addressed and rectified through that court process. So to avoid having to pass your accounts, keep proper accounts records, keep things very simple, and so you can hopefully avoid that unnecessary expense, because it would be an expense, an application with the court, and these can get expensive as well. And then lastly, the role of attorney or guardian, it is a serious appointment. So if you are considering on who to appoint, make sure that that person will act in your best interests and will be able to manage your finances appropriately. And then with your personal care, someone that's going to be present and assist if needed. And yeah. Next slide, please. So I thought that I would have a slide here just talking about some of the common issues that we see in power of attorney matters. So first, we see issues regarding the validity of power of attorney documents. So again, I touched on this briefly or previously. If they're concerned about the formalities of the document. So again, wasn't witnessed properly or wasn't signed by the grantor, that can cause issues. If a lawyer wasn't involved, or even if a lawyer was involved, sometimes things get missed. If there's capacity issues and undue influence issues, so if the grantor was incapable of granting a power of attorney for property, for example, and or was being influenced by someone to have that person execute that document. So we get some concerns or files concerning that. Again, misappropriation of funds by attorneys and guardians. We get a lot of these matters as well, and probably one of the more issues we see, again, with the estate accounting and passing of accounts. So make sure, again, keep proper accounts of your dealings as attorney and as guardian. And then we're seeing more of these types of scenarios. So contesting the validity of inter vivos transfers. So these are transfers made during the grantor's lifetime. So let's say an investment account suddenly gets put into joint names with the grantor and attorney for property, for example. And then on the passing, and again, as a joint appointment of the investment, upon the passing of the grantor, all the funds go to the attorney. So, there's issues concerning those transfers. Also transfers of property, that those seem to be in the joint appointment, those seem to be more common as well. So we get concerns about validity of those on the basis of incapacity and or undue influence. And then we get a few claims that are probably pertinent for nursing homes right now, but restriction in visitation access, but restriction at the person's home or at the residence, retirement residence or retirement facility, nursing home, and the restriction being denied, or visitation being denied by the attorney or the guardian. We see a lot of issues about that. And just as a point, restriction in visitation by the attorney or guardian, it can only be made if there is a safety concern. And so there is a higher threshold to restrict visitation access. And then I briefly talked about this earlier, when there are competing guardianship applications between usually siblings, when there hasn't been a power of attorney executed, or if there's been concerns about misappropriation of funds by another sibling. So we see that often as well. Next slide. So although financial elder abuse is not going to be present in all cases, obviously, that would be important just to go over some red flags that we tend to see when there has been inappropriate activity in an incapable person's accounts. So again, a restriction in visitation access. Often an attorney or guardian will restrict visitation access by family members, and like suddenly, and safety doesn't appear to be a concern. but all of a sudden there's a restriction in access and the person can't, and the family member cannot view their loved one or visit with their loved one. And then this is kind of tied to visitation restriction and visitation access, but manipulating how the incapable person views other family members. And we see this when there's capacity issues, and then again, the presence of undue influence. Usually there's a sudden change in the powers of attorney or the will that was executed, and it suddenly excludes certain family members or all members except for the attorney for property and personal care. Property transfers suddenly being completed, and it's usually benefiting one person or the person's family, and often it's the person that's the attorney for property. And then funds quickly disappearing from bank accounts and investments, but the person's spending habits have not changed. So that's usually a signal that there's something inappropriate happening. And then the incapable person not being aware of their funds and being told incorrect information regarding their funds, such as they don't have as much money that they had before, and there's no explanation really being provided as to like why. And then also the incapable person's spending habits being unnecessarily restricted. So then the control over what funds are being spent by the incapable person, that's usually a flag that we see. Next slide. So if you come across any of these issues, usually you'll need to resort and there's no compromise with family members. You can seek the assistance of a lawyer to assist with trying to resolve the matters, either through family meetings or mediation, or litigation can be commenced. So this is a picture of our team. This was done pre-COVID. So the team is still intact, but we have additional people that have joined our team. And so we all have various expertise in a variety of areas. So we do will disputes based on capacity and undue influence, disputes concerning the validity of powers of attorney documents on the basis of capacity and undue influence. We have an estate administration team that drafts wills and powers of attorney documents. Estate administration, again, we do guardianship applications, estate accounting, and more. So we've dealt with it all. And if you ever need assistance, we are here and happy to assist. Next slide. All right, so this is the question and answer period. These are some examples that I've listed. So let's see what questions we have.
All right, so I think we do have a few questions in the Q&A.
Okay, so should it always read jointly and severally to act separately? So I think, so this is in relation to the attorney appointment. So it doesn't always have to read jointly and severally. Again, the different kind of, if you're going to if you're going to appoint more than one person, there's jointly or jointly and severally. So jointly, they have to act together. Jointly and severally, they can act like separately. They don't need to have the consent of the other person for all decision making. If I didn't answer that, please let me know, and I can answer the other question.
Okay, sounds good. So I think, yeah, those first two kind of went together.
Yeah.
Okay, so, it's moving on me. What happens if a medical power of attorney is not in place when care is required or in an emergency? Does this default to the closest family member?
It depends on what kind of decision needs to be made. So if so medical POA, so power of attorney for personal care. So if, let's say, someone needs to be placed into urgently to a nursing home, we have found that a guardianship application was required. So we've had to do those urgently. But if it's an emergency regarding healthcare, there is the Healthcare Consent Act, which outlines the certain family members that can make those decisions. So spouse, children. So that is there for like consenting to treatment in a hospital healthcare. But I find if it's shelter and you're dealing with an institution, they want a court order evidencing that you have the authority to make that decision.
Okay. If a married couple has joint accounts, should that account be closed and two separate accounts be created, one for the attorney and one for the person who is declared not having capacity?
So it depends. If the married couple, so if both are, I guess it depends also who's the attorney in that situation. So if both spouses are incapable, and let's say there's different attorneys that have been appointed, then I would suggest having separate accounts just to keep things simple. And it depends on the living situation as well. Like if they're both in a nursing home.
I'm guessing in this case, it's a couple where one is incapable and the other is the substitute decision maker.
Oh, okay. Okay.
So should they have a joint account or separate accounts?
In that type of situation, and they are still living in, let's say, a property, I think it makes sense to keep a joint account in that situation. Like really, it's whatever method is going to make you be able to present your accounts later on. That's going to be clear and consistent with whoever, like, let's say if you need a lawyer to assist you, as long as you can demonstrate what the expenses were for, like what was their income. Like I only say the joint accounts just because I find like when it's not a married couple, and let's say there's a child involved, that's where we come across issues. And then also the joint appointment with rider survivorship. If you appoint your child with you on your bank account, and then if the person that it passes, like the funds in that joint bank account will go to the child. So that's another issue as well. So in that situation, I would say joint accounts is fine, particularly like if you're living in the same property and same expenses, right? Sharing the property taxes or insurance, whatever.
And if you've always had it set up that way, so there's a history of it always being a joint account, then.
Exactly. Again, in that scenario, I would also direct deposits into the account, direct withdrawals for expenses, make it clear cut.
All right. If you are a power of attorney for property, who may ask for an estate accounting or passing of accounts? Is there a time limit between requests, for example, once a year or more frequently?
It depends on what kind of accounting you are requesting. So if you're just asking for an informal accounting, so not like a passing of accounts court application, you can ask that. You can do once a year, 2 years, whatever works for that family dynamic. If it's a court application for a passing of accounts, we actually indicate the estate accounting period. We usually have 2-3 years. That's usually what's court ordered to present as an accounting. It could be longer though, depending on the time that's passed and since that person started acting. So yeah, so it depends on that. And then also who may ask for an estate accounting. So the grantor of the power of attorney can. The power of attorney for personal care, the public guardian trustee, or any other person with leave of the court. So usually other siblings, if they have evidence of that there may be concerns about misappropriation, that's been ordered.
Okay. Okay, so someone says, I've made arrangements for and I'm about to prepay for funeral arrangements. It is something that was discussed before a declaration of my spouse being declared as not having capacity. Would the withdrawal of this amount of money raise questions?
So as long as the withdrawal of the funds or the transaction is for that person's benefit, there should be no issue. So what I gather from this, you're prepaying for the person's funeral arrangements. And that's a valid expense of the person.
I think with everything, just keep receipts, right? Keep a record of.
Yeah, exactly. Yeah, receipts are super important. Checks.
All right, the next one. You talked about restrictions to visitation. I think you were referring to if the power of attorney or guardian is restricting access to the incapable person. Did you also speak about the reverse? For example, restrictions on power of attorneys or guardians visiting the incapable person. More specifically, I'm speaking about the person when he or she is in a long-term care facility.
So I didn't speak about the reverse. So restrictions on the POAs visiting or the guardian visiting the incapable person. So I have not come across that. So I'm not really sure about the context of what's happening and who's restricting access. I usually find that the attorney has the authority to make decisions concerning safety. So that's why they can make the determination of who can visit and who cannot visit if there's a safety concern. Like you have to show that there's a concern. Can't just restrict supporting family members based on the Substitute Decisions Act. So I would be surprised because I'm not sure who's restricting the access, but POAs have that authority. So usually it's that they are restricting the access that I've found.
All right, next. What is the best resource when a capacity test cannot be completed with consent of the individual due to mental health? So for example, the individual does not comprehend that there is dementia present and refuses to be assessed by a healthcare provider.
Yeah, so then I briefly discussed this. So these are difficult situations. If there is a safety concern about the alleged to be incapable person, a court application would need to be commenced seeking a court order that a capacity assessment be completed, and you have to present evidence to support why the assessment is needed, why it's a safety concern. And in that application, I didn't talk about this, but there is under the Substitute Decisions Act, Section 3, we have Section 3 counsel, and these are individuals who are appointed by the public guardian trustee, and they will meet with that person to gather their wishes regarding the capacity assessment. And then their job is to relay those wishes to the court. But if there is sufficient evidence to say that a capacity assessment is the best thing to do in the circumstances, then the court will order that. So that's the mechanism that can be used to deal with that.
And how do you go about doing that application?
So seek advice of a lawyer, and they will prepare the court application materials, which will be an affidavit in your name outlining what the concerns are and the safety concerns and the issues and the attempts to have that person assessed in their refusal. And then that's brought in the Superior Court of Justice. So it's a civil proceeding.
Another question, which you kind of addressed already, but so if there is a joint account between two POAs, should another type of account be opened? If yes, what type of account?
So the name of this account will vary from institution to institution, like banking institution. We always say it's a bank account to be held in trust by the attorneys or the guardians of property. So the account is still clearly in the person's name, but it is shown that there's a restriction and that the attorneys are there and they're managing the accounts in their role as attorney.
Okay. When or how often should a power of attorney be updated?
Well, you don't have to update it. It really, I think, definitely review it every uh, 3 to 5 years, or maybe review it after any material changes in the family dynamics, uh, just to ensure that the person that you've appointed or persons or how you've appointed them is still what you want. And because family dynamics change all the time. So you want to make sure that whoever you have there is the appropriate person. And again, geographic location, I find, is an asset.
If guardianship is applied for and granted and something happens to that person, should or can the passing of that guardianship be included in their will?
So if I understand the question correctly, so if the person, the incapable person passes, the guardianship that's been granted, it ends. So the guardian, it's similar to an attorney. The guardian has no authority, and it's now the estate trustee of the will that now has the authority to deal with the fine or the financial aspect of this person's assets.
So in reverse, what if the guardian dies? Like, what if the guardian's appointed and then the guardian dies? Then what happens?
So then there needs to be another appointment. However, if there is, and this is another consideration. So if you do have like 2 people appointed, they'll pass on to the next person. So we've had that. In that particular situation, an updated or an amended management plan and guardianship plan in support of that appointment would likely have to be made and given to the public guardian trustee. And then should or can the passing of that guardianship be included in their will? So if a passing of the previous guardian's accounts are necessary, whoever is that interested party. So if, let's say, it was the attorney for property is the same as the executor, or the guardian of property is the same as the executor, a person with a financial interest in the estate can ask for an accounting. If it's different people, the estate trustee can ask for an accounting, but I don't think it limits an interested person in the estate from also asking an accounting from the previous power of attorney.
Okay, follow up to the question earlier about the visitation restrictions. So more specifically, they're wanting to know what restrictions can the home, so the long-term care facility, put on power of attorneys or guardians?
That's an interesting question. I'm wondering, so if it's a safety, again, I've never seen this before, this allegation yet. So if it's a safety concern, depending on what it is, the nursing home, they do have their bylaws and policies in place. And if someone's not following the bylaws and policies, then I believe that they would have a right to restrict access. Thinking, for example, like COVID, if someone's not following the COVID measures, then the facility, if it's a public health and safety issue, they can make that determination, I would say, yes.
Okay, so this person says, I have informed a bank that my younger brother has named me as his continuing POA effective immediately and provided them a certified copy of the document. The bank asked that my younger brother meet bank staff to sign documents instead of me. Is this permissible?
Again, so it depends on what the power of attorney document says. So if it's a continuing power of attorney, and the person is incapable, and you're presenting the bank with that power of attorney, the bank should be able to follow your instructions. But then sometimes banks do require some evidence of incapacity because they don't want to be dealing with someone else when the other person does actually have capacity. So they may, depending on whoever this institution, they may want us to see like what's going on and whether if he's still capable or not, because they obviously want to avoid a situation of obtaining instructions from someone, but the person's still capable. Again, the power of attorney document can also specify the need for a doctor's note or capacity assessment. So, so it really depends on those circumstances, but maybe you and your younger brother can attend the bank and together and kind of discuss the situation of what's happening and why you presented to that document.
All right, the next one's kind of related to the banks and power of attorney as well. So banks often ask clients to complete their own power of attorney for property, like the bank's forms. Does this negotiate previous power of attorneys?
Well, so I've seen different POAs executed in the bank context. So like sometimes it's for only certain assets. So that would revoke the previous power of attorney to execute it for those particular assets. But if they're asking clients to complete a full power of attorney for property, that revokes previous powers of attorney documents. So I recommend the use of a lawyer for those types of situations, just to ensure that formalities are completed properly and capacity and undue influence is assessed.
All right. Is there any public guidance for these services if the process sounds like it will be costly and the senior may not have the funds to hire a lawyer?
So the public guardian trustee, they have great resources on their website evidencing the materials that are required for, let's say, a guardianship application. And also they have the management plan and guardianship plan forms online. And I believe that they have people that you can call just to ask for some guidance. They can't give legal advice, but they can direct you on where to go and a portion of the process. And then if you need to file and serve a court application, the courts have individuals that can assist there as well.
When there is no property involved, what kind of POA is needed?
So for property, so if they're, again, power of attorney for, excuse me, power of attorney for property involves real property, so land and also personal property. I generally find that there is some sort of property that the person owns, so power of attorney for property would be needed. And then if you're not considering property, then we have the power of attorney for personal care, which deals with personal care decisions.
What does the runway look like from contacting a legal firm to obtaining a guardianship? Weeks, months, years, kind of timeline?
So there's a couple factors that impacts the timeline. So if, let's say, it's a straightforward guardianship application, there's no family member that's going to contest that application, because if someone's going to contest it, it's going to create further litigation, and it potentially could take a year. But if it's a straightforward uncontested guardianship, I would say a few months, because you need to assist the lawyer with obtaining the financial and personal care information. But then once all that's completed and the materials are finalized, we have service requirements. Generally, we do it's 10 days, but we do about 3 weeks. And then we just do it bring it on a motions court date in London. And those are every Friday.
Okay. So could be a few months if it's not too complicated.
Yeah.
Longer if it is.
Yeah.
All right. Can you please reiterate the exact name of the Healthcare Act that names the people that can make emergency healthcare decisions for someone? So
it's the Healthcare Consent Act. So if you just Google it, so I have it actually right in front of me. So it's if you need the legislation, so it's the Healthcare Consent Act, S0 1996, Chapter 2, Schedule A. But if we Google Healthcare Consent Act, we should be able. It'll come up. Yeah. Okay. Great. Okay, that is all the questions that are in there right now. So unless anybody has any others they want to quickly add, got perfect timing. So yeah, I want to thank you, Leanne. That was
great information. It's so complicated, especially when the situations get a little messy, right? So it's yeah, great to hear yeah, all of that information about capacity and the different situations. Yeah, like when power of attorneys don't agree, and the whole about guardianship and all that, right?
Yeah, it's ever evolving, and I'm always seeing new situations and learning new things. So and it's just going to get more busy, I guess. And but yeah, if you have any other questions, feel free to email me also after the presentation. And yeah, so
Great.
thank you so much for having me.
Wonderful. Well, thank you. And to all of the our guests today, we will mail out a satisfaction survey later in the week. So if everyone could just take a couple of minutes to fill that out, it'll be a SurveyMonkey link. That would be wonderful. We really do appreciate your feedback. Let's see, one more thing in the Q&A. Oh, one more question. Is there another way to get some support, get questions asked via this format? Not exactly sure what she means, but if you want to reach out to us, we can pass on messages to Leanne or give you Leanne's contact information after the meeting. All right, thank you, everybody. Please have a good afternoon. Take care.
Great. Bye. Thank you.
Bye. Thanks, Leanne.